Well, welcome back, everybody. So, this is going to be the part 2 lecture for chapter 9. And if you remember, we were talking a little bit about the identification process, and we talked about the procedures that have been put in place by the U.S. Department of Justice and the American Bar Association, and some of the modifications and some of the goals. And I also left you with kind of a question, and that was to consider whether either those three goals, or what we're going to look at here shortly, and you haven't seen that yet, of course, would have prevented Jennifer Thompson from identifying Ronald Cotton as the man who raped her. So let's consider these innovations as we go through and discuss them on whether or not you think that might have changed something. So the first modification would be what we would call a blind administration. And what this is where the officer or the person that is administering the identification should not be informed on which person in the lineup is the suspect. And typically, again, this can be for both the live lineup or it could be for the photographic lineup. So again, in summary, the person that's administering the identification should not be informed on which person is the actual suspect. And this prevents the administrator from unintentionally or even intentionally influencing the selection. So hopefully that kind of makes sense. Next would be what they would call a double blind. And this is when neither the investigator nor the administrator of the ID is informed on which person in the lineup, whether it's the live lineup or a photographic lineup, is the suspect. And that process, you can kind of figure it out. Since the first one was blind, well, this is double the people, so it's double blind. And I will show you what that looks like as we go on, and I have a couple videos as well. Another consideration would be the instructions, where the administrator informs the witness or the victim that the person may or may not be in the actual lineup. And that's really important because this eliminates the possibility that the eyewitness will look to the administrator to guide his or her selection, or in actuality, it will make them to where they don't feel compelled to single out an individual as the suspect, meaning you don't feel the pressure to have to pick someone. And moreover, following the identification, the police really should not indicate that the witness has selected the correct person, because these suggestive comments may unduly influence the suspect's future identifications or future processes. So hopefully that makes sense. The next one would be what we call a single eyewitness. And this is where only one person at a time should view the lineup, the show up, or photo lineup. And in addition to that, eyewitnesses should not be allowed to speak to each other during that process. And you could probably understand why, because this will prevent the witnesses from basically influencing each other. And a witness also should not be told who was identified by the other individual. So let's say you were coming in to do a lineup. I shouldn't tell you, hey, the person before you picked number 2. You see how that can influence something? So witnesses, where possible, also should not be shown the photographs of the suspect or permitted to view the suspect prior to the lineup. So what we want to do, again, these are all um, basically innovations that we were hoping, and a lot of departments actually do this now, would eliminate any of the inaccuracies, especially maybe, again, I kind of asked you what would have happened in the Jennifer Thompson case. So confidence, and this means that once an ID is made, a kind of a reform proposal would require the officer to ask the witness to what degree of confidence the witness or the victim is in his or her selection of the suspect. Meaning, if you selected, let's say, number 2 in a photo lineup, the officer would ask you, well, to what degree of confidence on a scale of 1 to 10, or on a percentage from 0% to 100%, but they're asking for a degree of confidence. So if somebody said 50%, that's maybe not that good. If it's 100%, that's a heck of a lot better. And you can see how much more emphasis is kind of placed on that. And then, this would be the identification. So kind of for fun, I had members of the MSJC Criminal Justice Club do basically a artist sketch, a composite sketch on me. And they used a computerized version of what we call Identikit. Now, this used to be where they had plastic sheets of, little plastic sheets with like foreheads and heads and faces and mustaches and eyes and eyebrows and noses, and you would stack them on top of each other and kind of like build a face. Well, now they have this system computerized. And this is the face or composite that they came up with me. Now, I think they kind of ripped me off a little bit on the hair, but yeah, maybe not. But this is a photograph of me. And I gotta say, what would be the percentage, the accuracy on that? I gotta give them, if I want to be really honest, I gotta give them like an 80 or a 90. I think they did really, really well. So what do you think? Does that look like me? Yeah. Again, I think they kind of ripped me off a little on the hairline, but maybe not, looking at the picture now. But anyway, okay, so the next one would be sequential presentation, and we talked about that earlier. So a standard or simultaneous is another word for it, would be all at once, where you view all the photos at the same time, or you view everyone in the lineup at the same time. Now, a sequential is where the participants in the lineup, or in a photo lineup, are presented to the victim or the witness one at a time. And the person is asked to make a decision about each person immediately following the viewing. So that eliminates the possibility of you comparing. Because realistically, within 15 to 20 seconds, you should be able to pick somebody out. And if it takes you 4 or 5 minutes, then you're thinking too much. You're comparing. So hopefully that sequential would work a little bit better. And I have a couple of videos. We're not going to look at them, but I've given you some information on how a blind administration works and how a non-blind does in sequential. And here again, I have a sequential photo lineup and a sequential lineup. So you can watch the two videos, the different presentations that are here. And that will help you. So at your leisure, take the time to watch it. I even gave you a little bit more information about a standard lineup versus a blind and a double blind. So again, quite a bit of information. But to kind of bring it home, and you could actually print these out, and you could take this home and you could show it to someone in your family and see if they could pick them out, or which one is harder. Now, you would have to decide here which one of the 6 was your suspect, and what you would do is you would take this photo and just show it to them for, say, 10 seconds or whatever, and then let them sit for a minute or two, and then show them all these pictures and see if they could pick them out. But would it be harder this way? So what if I just showed you one photo? And then I showed you another photo, and then another one. And I have to show you all of them because, you could change your mind. So we walk through all of the pictures. So which would be harder or more fair? Would it be sequential or all at the same time? So in 2003, the National Institute of Justice, or NIJ, published a manual for training in identifications for law enforcement. And the manual discusses one of the most difficult issues, the composition of a lineup or a photo lineup. And some of the things that were in there that they talk about, we're going to go through. And the first would be balance, meaning that if you're going to do a lineup or a photo lineup, the individuals in that identification should be similar in age. Think about it. You can't have, say, if it's a photo lineup, you can't have 5 individuals that look like they're 18 and one person that looks like they're 45. That's too suggestive. So a balance in age or height or weight or even dress. Now understand, in order to make that balance, the court has given us a little bit of leeway to where if the suspect was wearing, let's say, a red hat, you can put a red hat on everyone, or a black jacket, or whatever. So you are able to do a little bit of, dress up or whatever you want to call it in order to get someone to closely resemble. And it can't, it's not going to be perfect, but you want it to be as close as possible. Next would be distinctive features. Things like tattoos or hair, because fillers in the lineup, meaning the other people, should possess the offender's distinctive features mentioned by the victim or witness in the lineup. And courts have upheld the right of the police to order participants to, let's say, shave or cut their hair or alter their appearance. And individuals may also be required to speak or to make physical gestures like, holding up a peace sign, or, make a gun with their hand, or whatever it is that the suspect had done. In addition, we'll talk about that in a minute. Now, next would be the number of people. So typically at minimum, at a minimum, 5 fillers in a photo lineup and 4 fillers in a live lineup are to be included to reduce the risk that an individual has selected as the result of a guess. So again, most photo lineups are done with 6. Sometimes it's 8. If it's done with 6 photos, 1 is going to be the potential suspect and 5 will be the fillers. If it's a live lineup, and again, typically it's going to be, between 6 and 10. So 1 is the potential suspect and the others will be the fillers. Next would be preservation, meaning that following a lineup or a photo lineup, the results should be recorded by the police on a standard form. And this typically involves recording the number of the lineup member who was selected, the name of the witness, the date, the investigator, and ideally a statement describing the identification. Like if the person says, yeah, that's him, then you would write that down. And the lineup or the photo lineup should be photographed or videotaped. And photograph lineups also should be preserved to defend against any type of legal challenge. So, and each eyewitness should complete a separate form indicating the assigned number of the person that they selected. And that kind of makes sense. And the reason, again, for the photo lineup is Rialto, when I was there, we would actually book that photo lineup into evidence. And that way, if we had to go to court and defend it, we would bring the original photo lineup into court, and the jury would be able to see that photo lineup, so it hasn't been altered. So that's the preservation. And then finally, photographs. The photographs in a photo lineup should be uniform, meaning, similar or neutral in appearance to avoid any influence. And the photo should not, you can't mix like color with black and white because that would be unfair. And there should be no visible identifying marks, such as writing on the back of a picture that someone has been indicted or imprisoned or etc. So you find a plain photo of each individual. Now, when it comes to photos, the courts have held that if the suspect has a scar and that's in the photo, that you can actually Photoshop in a scar on somebody else's face. So that's been something. So you can use a little bit of adding to the photo to make everybody have the similar appearance. But in one photo, you can't have like a booking number above it when nobody else has like a number. Does that kind of make sense? So you want them all to be neutral appearance to avoid any type of influence whatsoever. Okay, so hopefully that kind of helped out a little bit. But now we're going to talk a little bit about the Sixth Amendment and eyewitness identification. So in 1967, the U.S. Supreme Court announced in United States versus Wade that the existing system in which suspects are unrepresented by a lawyer at lineups violated the Sixth Amendment right to counsel. And again, that's the United States versus Wade case. And the holding in Wade was later affirmed and clarified by another court case, by the Supreme Court in another case, decided actually, I believe, on that same day, and that was Gilbert versus California. And out of these two cases, came about what is known as the Wade-Gilbert rule. So the U.S. versus Wade case talks about the fact that suspects in a lineup must be given the opportunity for counsel, and that the right to counsel, and we talked a little bit about this earlier, applies at all critical stages of a criminal proceeding, and that would include any of the startup adversarial type processes like a preliminary hearing or even an arraignment. Remember, we talked about a live lineup. You're entitled to an attorney. We talked about the fact at a photo lineup you are not, because there's no adversarial process taking place yet. And even at that infield, you're not entitled to an attorney because the adversarial process hasn't started yet. But at a live lineup or a live show up, if lineup and show up is the same in this particular case, then yes, you would be entitled to an attorney. So again, out of this came the Wade-Gilbert rule, which is a suspect has the constitutional right to a lawyer at all post-indictment lineups and confrontations. And, this means lineups, result at trial. Absence the presence of a lawyer or a waiver, the results cannot be introduced at trial. And it also talks about in-court identifications, that a prosecutor may not ask a witness for an in-court identification of the defendant unless the prosecutor establishes by clear and convincing evidence that in the court identification, it's not the product of an identification at which the suspect was denied a lawyer in violation of the Sixth Amendment. So does that kind of make sense? So the right to a lawyer at all post-indictment, meaning after you've been indicted or charged, okay, you are entitled to an attorney. And that feeds into the trial portion. So if there was a violation of this, of the lineup, of the being allowed to have an attorney at a lineup, the prosecutor may not ask a witness for an in-court ID. Again, unless the, unless the prosecutor can establish by clear and convincing evidence that the in-court ID is not the product of a identification where the suspect was denied an attorney. So hopefully that kind of makes sense, and I know it gets a little bit confusing, but that's the Wade-Gilbert rule. So now we want to talk a little bit about, we outlined the Wade decision, but a little bit more is to kind of explore why the Supreme Court ruled that Wade had the right to a lawyer at his post-indictment, identification or during that type of proceeding. So the U.S. Supreme Court held that Wade was in fact entitled to the guiding hand of counsel at the lineup, and the Sixth Amendment provides that in all criminal prosecutions, remember, it says the accused shall enjoy the right to have the assistance of counsel for his or her defense. Now it says his. The Supreme Court majority explained that the Sixth Amendment right to an attorney applies at critical stages of a criminal proceeding. And critical stages are those procedures following the initiation of a criminal proceeding at which a failure to provide a defendant a lawyer may prevent him or her from getting a fair trial. So again, a lot of legal ease there, but why is a lineup critical? We've talked a lot about this now. We've talked a lot about, hey, you're entitled to an attorney, and, especially at a critical stage in the trial. But why is the lineup so critical? We just said here that, critical stages are those procedures following the initiation of a criminal proceeding at which a failure to provide a defendant an attorney may prevent them from obtaining a fair trial. So why is the lineup so critical? So I'm going to give you kind of a second to think about it. Well, we know that a victim or eyewitness who identifies an individual as the suspect in a lineup is likely to identify the same person when testifying at trial. And that actually happened in the Jennifer Thompson and Ronald Cotton case, so hopefully you've seen that. And again, remember, as we said earlier in the lecture, these courtroom identifications tend to really heavily influence the jurors when you point at somebody and you say, that's him or that's her. So it's a critical thing. And again, remember the Ronald Cotton case. So a mistaken identification in a lineup may then contribute to the conviction of an innocent person. So that's really the importance, and that's why they've kind of held this to be a critical stage. And a lawyer, if they're present at a lineup, provides a defendant with a couple levels of protection, typically 2. And that is protection at the identification, meaning that a lawyer's observations of a lineup provide an incentive for the police to ensure that the ID process is fair and reliable, and it's not suggestive because, hey, somebody's there making sure that that takes place, right? And then second would be protection at trial. And the lawyer at a trial is then able to point out to the jury that the lineup may have been or was unfair, and then have the opportunity to argue that the jury should question the accuracy of the identification or the process that the police used, and that makes sense. So that's the critical nature relating to lineups. So, kind of a wrap up, the Supreme Court in Wade pointed to numerous instances of suggestive procedures to illustrate why defendants would then require the assistance of an attorney at, what we're talking about would be a pre-trial lineup. So let's kind of look at some of those. So the court highlighted a few of the common practices. So first, everyone in the lineup other than the suspect is known to the victim. So think about, remember we're talking about, this is the, suggestive procedures or suggestive lineups. So the court highlighted several common practices. Number 2, the suspect is the only person in the lineup whose physical appearance and dress matches the description of the suspect. Remember, I talked about the fact that people need to look the same or somewhat the same, even in their dress. Number 3, the people in the lineup are asked to try on an item of clothing that fits only the suspect. Could that be suggestive? Number 4, the police point out the suspect prior to the lineup. And then finally, number 5, the victim is asked to identify whether a person in a jail cell is the suspect. And again, if they're sitting in a jail cell, remember we talked earlier about how it's possible that an infield show up, that because the person is handcuffed and standing next to an officer, that it might be a little suggestive, which is why you read the information saying that this person may or may not be the person, etc. Well, if this person is in a jail cell, would you be a little bit influenced that maybe that person was in fact the person? So you might. So again, these are some of the threats of suggestive lineups and why the Supreme Court in Wade kind of ruled the way that they did. Okay, so another case that came up that we're going to talk about a little bit would be pre-arraignment identifications. Again, we're going to kind of stay with that a little bit. And in Kirby versus Illinois, the U.S. Supreme Court held that a show-up following an arrest, but before the initiation of adversary criminal procedures or proceedings, whether by the way of formal charge, preliminary hearing, indictment, etc., is not a critical stage of criminal prosecution at which the suspect is entitled to counsel. So here's a little bit of, kind of a little bit of stepping back, and they're kind of defining where that critical stage is. So remember I talked about the infield show up. Now I think in your textbook, a lot of times, they list show up and lineup, and sometimes they kind of make it sound the same. A lineup is with, is typically an in custody thing. But an infield show up happens in the field. But if somebody, if that show up takes place, again, following the arrest, but before that adversarial criminal proceeding begins, the Kirby case said that, hey, they are not really entitled to an attorney. And another case that came along shortly after that would be the Moore versus Illinois case, which basically kind of had the same outcome. So here's the legal equation, and kind of a lot there. Let me back up. Talks about a lineup. Here again we have the critical stages, and then and kind of why the lineup is a critical stage. And then here we have the inadmissibility of pretrial identification of a suspect, meaning that maybe the person wasn't entitled to an attorney. So you can kind of see the and then here the admissibility of in-court identification, where an attorney not provide, where there was no lineup or show up. So a couple of legal equations for you to look at, and it gives you the test and everything else. And then finally, the pre-indictment lineup and right to an attorney. Again, and this kind of refers a little bit to the Kirby case. Okay, so another very interesting case that I think it's important for us to kind of point out would be United States versus Ash. And this is really important as it relates to photographs, and we've talked a little bit about the Wade case and stuff like that. But in 1973, well, let me back up. In United States versus Wade, remember, the U.S. Supreme Court held that an individual had no right to an attorney to observe things like the taking of fingerprints, hair and blood samples, and other tests that relied on standard scientific techniques and procedures. Remember, we talked about that? And the court reasoned that the defense attorney and defense experts could easily examine the test results and procedures following the test, and therefore effectively cross-examine the police laboratory technicians at trial. But now we're going to talk a little bit about photographs, a little bit more in detail. So what about photographic identifications, photo lineups? Because those happen quite a bit. So we're going to kind of combine the Sixth Amendment and photo lineups. So things like photographic displays, or what they call non-corporeal identifications. So these photographic displays pose a particular challenge sometimes. On one hand, the defense attorney typically is informed of the results of an identification and is able to examine the photographs to detect whether the suspect's photo was larger, or let's say more colorful, or distinguished in any fashion from the other pictures. And on the other hand, unless a lawyer is present, there's no way of really knowing what occurred during that identification, right? So in 1973, in United States versus Ash, the U.S. Supreme Court held that a post-indictment photographic display is not a critical stage of the prosecution, in that the Sixth Amendment does not entitle the accused to the presence of an attorney. So again, the U.S. Supreme Court held that there was much less need for a lawyer at a photographic lineup or a photo display rather than a regular lineup. Does that make sense? So again, a kind of interesting case, the Ash case, but this one kind of backs up for us a little bit, or backs up the fact that people aren't entitled to an attorney for a simple photo lineup. And then here's your legal equation that kind of goes with it. All right, let's talk a little bit about due process, and then we'll wrap things up for today. So we have seen that suspects involved in lineups and photo lineups following the initiation of criminal proceedings are entitled to representation of an attorney. Remember, so this is following those proceedings. And the dissenting judges pointed out that this left suspects in lineups or show-ups conducted prior to the initiation of criminal proceedings and photo displays with little protection against the suggestive identification process. On the same day that the Supreme Court decided that the cases Wade and Gilbert, and yeah, this is criminal law, the court responded in another case, and that would be the case of Stovall versus Deno. So the court responded in this case to the concerns of the dissenting judges and held that suspects during the pre-indictment phase are protected by the due process clause of the 5th and 14th Amendments against identification procedures that create a likelihood that an innocent person will be misidentified and deprived of life or liberty, which would be, say, the death penalty or prison, without due process of law. So, in other words, the due process test applies to lineups and show-ups and photographic displays, whether pre-indictment or post-indictment, right? But that doesn't mean they're entitled to an attorney, but you just have to make sure the procedures are correct. So still, the photo lineup, they don't get an attorney. And an infield show-up, they don't get an attorney. Even in being arrested, but right before those the identified critical stages that happen, the adversarial stages that start to happen, they're still not entitled to an attorney, but once that critical stage starts, they are. But the Stovall case does apply and says that they're still entitled to due process, which means proper procedures. And that's whether or not they have an attorney. So hopefully that kind of makes sense as well. So again, a couple of really important cases, and I know that sometimes there's a lot of, the legalese stuff like that. But here's your legal equation that talks about due process. And you can kind of take a quick look at that, and then I'm going to finish up. All right, so we're going to finish up with suggestiveness, reliability, and this totality of circumstances. So a couple of cases that talk about the totality of circumstances. One would be the Manson versus Braithwaite case. Now, the U.S. Supreme Court basically said that a single photo identification is so suggestive that it runs the unreasonable risk of suggestiveness and bias. And the fact that a procedure is suggestive does not mean that the identification is inaccurate and should be automatically excluded from evidence, but we're going to look at it on the totality of the circumstances. And there are times, let's say, where somebody might be identified maybe out of a yearbook or something like that, where there's only one photo. Or someone, the officer sees a photo and goes, is this the picture? Maybe it's a family member or something like that. So this case kind of deals with a single photo. But again, the Supreme Court in the Manson versus Braithwaite case adopted this totality of circumstances test to the admission of identification under that due process type test. Again, looking at the totality of circumstances. And then there are a couple of other cases that I'm just going to kind of throw out. I'm not going to go through each one, but this talks about the application. The Neal versus Biggers case in 1972 talks about the application of the Braithwaite test. So the test itself, realistically, talks about reliability. And, when we kind of back up to the totality of everything, we want to make sure that the tests they're not suggestive, and again, that they're reliable. And the test reliability is basically the central question in determining whether an identification violates due process of law. And here, reliability is determined, again, by the totality of the circumstances, considering various factors relating to the witness's observation of the offender. And the judge is basically going to use some factors to consider the reliability of someone's identification. And one of those factors might be perception, meaning the opportunity to view the offender at the time of the crime. The next would be concentration, the ability to focus on an individual's appearance. Accuracy, the accuracy of the description of the suspect following the crime. Certainty in the identification of the defendant. Time, meaning the length of time that has lapsed between the crime and the identification, and then other evidence, which is additional evidence that the defendant was in fact involved in the crime. So, I mean, these factors tell us that we should have confidence in the identification of an offender by a victim or an eyewitness who closely observed an offender for a lengthy time period. Now, you have to kind of, keep in mind that on the other hand, we may question the identification of an offender by a victim or an eyewitness who doesn't have the opportunity to clearly view the offender. So the reliability of identifications are based on the totality of the circumstances. Again, you've heard that kind of said a lot of times. Another case really quick to talk about is Perry versus New Hampshire. In 2011, in Perry versus New Hampshire, the U.S. Supreme Court addressed the issue of eyewitness identification for the first time in several years, because we haven't really looked at some of these in a long time, and some of these other cases have kind of come about. But let me kind of finish up here with the factors, these reliability factors that we talked about. So these factors, again, are to be weighed against the fact that the witness may be influenced by suggestiveness of the identification, and the court must determine whether, based on the totality of circumstances, the suggestive procedures create a very substantial likelihood of irreparable misidentification. In other words, did the identification result from the observation of a suspect at the scene of a crime, or did the identification result from the suggestive identification? And the judge will have to rule whether the identification is going to be admissible or inadmissible. And by definition, just to tell you, admissible means that the witness may testify, and inadmissible means that the witness may not testify. So hopefully that kind of clears that up. All right, so the last thing, and we'll be done, would be quickly talking about scientific identification. So judges are the gatekeepers who screen the evidence before it's presented to the jury. And the criminal justice system relies on trained scientific experts to analyze clothing and fibers and hair and blood and handwriting and voice pattern and ballistics and footprints and fingerprints and all that stuff, just to name a few. And there is a particular challenge to ensure that the technical and often confusing scientific evidence that lawyers want to introduce at trial is based on recognized scientific procedures. Because some of these procedures, they're great. They can actually prove guilt, or they can exonerate or eliminate a person. Now, some of the tests that kind of came about, the traditional test for the admissibility of scientific evidence was in 1923 in the Fry versus United States case. And here, the Fry test asked whether a scientific technique or approach is sufficiently established to have gained general acceptance in the particular field in which it belongs. So things like, you can kind of think about that. So polygraphs, I kind of asked you that question earlier. The polygraph test is not an accepted test because it really isn't accepted by the field, and there are some other issues. Now, the Daubert versus Merrill Dow Pharmaceutical in 1993, this test developed a bit broader view than the Fry test and asks a judge to study the research and views of experts and to reach his or her own conclusion as to whether a scientific technique will assist the trier of fact to understand the evidence or to determine a fact in an issue. And in most cases, either approach tends to kind of lead to the same result. I mean, consider the applications of DNA in the criminal justice process. It's used to connect an individual or individuals to various criminal acts, and it basically identifies or includes or excludes an individual as a suspect, meaning that it may establish guilt or innocence at trial. And some, folks basically are concerned with viewing DNA as infallible, meaning that there is some possibility for mistakes. DNA was first used in criminal cases back in 1986, and it is now considered admissible by virtually every state and federal court. And there's a really cool case that we don't have time to go over, but it's the Maryland versus King case. And I have a link to the case and also to the video, a short, probably about a 10-minute video on the Maryland versus King case. DNA was used to solve the Grim Sleeper case, which was a really cool case if you were to take the time to kind of go through it and look at it. That was kind of cool. DNA also helped solve the Golden State Killer case, a really recent case. And there's a 3-part series on it, and it's an excellent case study. A little bit more on DNA. There's CODIS. The definition is called the Combined DNA Index System, and NDIA is the National DNA Index System. And the National DNA Index contains over 12 million offender profiles and probably close to 3 million arrestee profiles and a little over almost 800,000 forensic profiles after 2017. And as of July 2017, CODIS has produced over probably almost 400,000 hits, assisting in almost 400,000 investigations. So really, DNA is used quite often. Quickly, polygraphs. Again, what a polygraph does, if you don't know, it measures a person's psychological responses to questions that are asked by a trained examiner, and it is generally not considered admissible. Now, you can still use it as an investigative tool, but you can't, it will not be accepted in court. So again, it's not accepted. It's not generally accepted by the scientific community, and it has not been established as reliable and I have a video on how it works if you want to know a little bit more. There is one case where it's the case of United States versus Sheffer, where the court affirmed the constitutionality of the prohibition on the introduction of polygraph evidence at military court-martials. So I mean, there you go. There is kind of one case, but in New Mexico does have a rare law that allows lie detector tests. So, you know, New Mexico is the only place. Okay, so a lot of information that we covered. I thank you for hanging in there. But again, it's a lot of information to go over. So this is going to conclude part 2 of the Chapter 9 lecture on eyewitness and scientific identification. And until next time.